Welcome, class, Political Science 200. This is our second lecture on the Judiciary, and today we will be going over court terms. So, the first court term that we're going to go over is judicial self-restraint. And this is a philosophy proposing that judges should interpret the Constitution to reflect what the framers intended and what its words literally say. Right? Judicial self-restraint. So, kind of the classic example of judges exercising judicial self-restraint is with the mathematical provisions in the Constitution. Right? That's what people who believe in judicial self-restraint like to use as an example. So, say you believe in... Say you believe in judicial self-restraint, you use the example of how old members of the House of Representatives need to be in order to be elected. So how old do members of the House of Representatives need 35. To be?
No, I'm 30.
25. Right? Yeah, 25. And people who believe in judicial self-restraint would say, clear as can be, 25 years old, right? How old do you have to be in order to be a U.S. Senator?
30.
30. Very good. How old do you have to be in order to be President of the United States?
30.
35. Yep. So, really clear. People who believe in judicial self-restraint say it's as obvious as could be. But there are other situations where it's not as clear. A good example are some cases done with the Confrontation Clause, right? Now, the Sixth Amendment says that you have the right to be confronted with the witnesses against you. Right? Now, what do you think that means? Confronted with the witnesses against you.
Evidence.
What?
It's in your favor.
Confronted with the witnesses against you. You guys have probably seen a lot of crime dramas. When a person is accused of a crime, does someone have to take the witness stand when they testify against the person? Yes. Right. That's what it means to be confronted with the witnesses against you. The person who is witnessing against you has to be in the courtroom. They have to take the witness stand. There was a case that reached the Supreme Court where a state was allowing people who'd been victims of abuse, primarily women and children, to testify behind a one-way screen, so that the person who was accused of the crime could see the person testifying behind the screen, but the person behind the screen, the victim of the abuse, didn't have to look at the alleged abuser. Right?
Yeah.
Okay. So the question became, was that arrangement constitutional or not?
I think it is.
You think it is?
Yeah.
Well, the court would not agree with you. The
Jerk court.
The court said it did not satisfy the Confrontation Clause, right? And Scalia wrote the majority opinion, and the opinion rested on the idea that the Confrontation Clause allowed you to confront the witness forehead to forehead. Confrons is from Latin, which means with the forehead. Con, with, frons, forehead. Forehead to forehead. Right? And so, were one-way screens available at the time of the founding? No. Right?
Technology.
Well, right. Yeah, it's a change in technology. And Scalia said, look, if you want to make these procedural modifications, then do it through a constitutional amendment. But, yeah.
We have those.
We have those. We are allowed to have constitutional amendments. But he said you can't make these types of procedural modifications just through regular old laws. It violates the Constitution. It violates the Confrontation Clause of the Constitution. Right? Mm-hmm. Okay. So, there are other examples of this. At the time of the founding, was the death penalty considered cruel and unusual punishment?
I don't think so.
No.
Yeah.
It was not considered cruel and unusual punishment. It was definitely on the table. As a matter of fact, the Constitution itself mentions that there may be capital cases. That is, cases where you could lose your head. Capital punishment.
Off with it.
Yep, well, exactly, And so the founders felt that capital punishment was not cruel and unusual punishment. But some people today think it is cruel and unusual punishment. And Earl Warren, Chief Justice of the Supreme Court, said the Eighth Amendment must draw its meaning from the evolving standards of decency that mark the progress of a maturing society. Right? So, did Earl Warren feel that the meaning of the Eighth Amendment changed?
Yes.
Yes. When I listened to Scalia lecture at Texas A&M, he specifically mentioned that line by Earl Warren, and he vehemently disagreed with it, right? He felt like the Constitution just doesn't change, right? Okay, this takes us to the second term, which is judicial activism. This is kind of the opposite of judicial self-restraint. And judicial activism is a philosophy proposing that judges should interpret the Constitution to reflect current conditions and values. Right? So, under judicial activism, that's kind of the idea of a living Constitution. The idea that the meaning of the Constitution changes depending on the times. So, are we one of the only countries that still uses the death penalty? Western industrialized countries.
I think so, yeah.
Yeah, we are.
One of the last ones.
Yeah, exactly.
It's not some Canada's using, right?
We're an international anomaly. Other Western industrialized countries do not use the death penalty. Okay? So, and that's, in general, they don't use it at all, right? Whereas we use it a lot, right? Well, the question came up, what about executing the mentally challenged? Those with IQs below a certain level. Is that cruel and unusual punishment to execute them? What do you think? Is that cruel and unusual punishment to execute the mentally challenged?
Oh, I think so.
You think so?
Court doesn't agree with me?
No.
Jerk court?
No. Actually, the court did agree with you.
Oh, nice.
Yeah, they said it's cruel.
Way to go, court.
It's cruel and unusual punishment to execute the mentally challenged. Now, guess who did not agree with the court at the time?
Oh, was it Scalia again?
Scalia did not.
This guy.
Yeah, Scalia did.
Tell you, I really spiced up the election.
Scalia did not agree with the court. He was very upset with this, and he says what the Constitution guarantees you is a trial by jury, right? So Scalia felt that instead of a psychologist deciding whether or not a person knew what they were doing, according to Scalia, who should decide whether or not a person knew what they were doing?
The jury.
The jury. And are you guaranteed a jury trial in criminal cases? That's right, a jury trial by your peers.
Yes, you are.
And so that was Scalia's argument, is we should stick to the Constitution. If people want to make the mentally challenged ineligible for the death penalty, then what should the people do?
Oh, make an amendment.
Pass a constitutional amendment.
He's the guy that follows the rules on the board game box, even if everyone else agrees that they're different. He's one of those people.
Well, he follows the rules, right? And if you don't like it, pass an amendment. We have an amendment process.
It takes forever.
Well, that's his point, is in democracy we should be having vigorous, robust debates. And if you don't like the way things are going, pass a constitutional amendment, but don't file a lawsuit and ask language-stretching judges to change the meaning of words for you or what the framers intended for you. That's his argument, right? Now, again, this kind of gets interesting in certain areas because look at the 14th Amendment. Well, part of the 14th Amendment, due process and equal protection clauses. No state shall deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the law. Right? The 14th Amendment is one of the Civil War amendments. 13th, 14th, and 15th that were passed shortly after the Civil War. Right? And when those words were written, no state shall deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. When those words were written, were they intended to try to encourage racial equality or gender equality? Racial equality, exactly, right? Now, time has passed, and in the early 1970s, were those words used to try to ensure gender equality?
Yes.
Yes, they were. And a guy like Scalia would say that's not what those words were intended to guarantee. They were intended to guarantee racial equality. If you want those words to...
Oh, so now Scalia can interpret things now, can he?
Well, that's his point, is when the 14th Amendment was passed, were there all kinds of state laws that treated men and women differently?
Yes.
Yes. When the 14th Amendment was passed, did people say, oh, all these laws that treat men and women differently are now unconstitutional? No. And so that's his point, right? Is just because now we think equality also extends to gender, that's not the way the 14th Amendment was understood when it was passed.
Oh, still had Jim Crow.
Well, you really got Jim Crow laws with Plessy versus Ferguson, 1896. But you see his point?
I do.
Can you at least admit he has a point?
I admit Scalia had a point. Do I agree with it? No.
Okay, well, that's fine. And that's what makes American politics interesting, right? But he has a point. Okay, next, stare decisis. Sometimes called stare decisis. Just so everyone knows, in Latin, all C's are hard C's, classical Latin. But it gets pronounced stare decisis, stare decisis. Anyway, it literally means to stand by the law. In Latin, stare, to stand, that's the infinitive for stand. Stare, and decisis, by the law. And this is, or by the decision. Sorry, to stand by the decision. This is the rule of precedent whereby a rule or law contained in a judicial decision is commonly viewed as binding on judges whenever the same question is presented. Right? Okay, so Okay, so we've discussed Griswold versus Connecticut and Roe versus Wade. Right? Before. Okay. Roe versus Wade was decided in 1973. And it said basically that women have the right to privacy. And the right to privacy is sufficiently large to encompass a woman's decision whether or not to terminate her pregnancy. Right? Mm-hmm. So the court in 1973 decided women have the right to an abortion. Okay? Mm-hmm. Well, if you're on the Supreme Court, mm-hmm. even if you personally disagree with that ruling,
yeah.
if you believe in stare decisis, then do you believe women have a constitutional right to an abortion?
Yes, stand by the decision.
Yes, stand by the decision. Exactly, right? So this is one of the things that kind of upset conservatives so much about David Souter, who was appointed by George Herbert Walker Bush, right? What's that?
I said H.W.
H.W. Bush, Papa Bush, right? So Souter was appointed by Papa Bush. Conservatives kind of thought he was one of them. And then a case reached the Supreme Court in 1992, Planned Parenthood of Southeastern Pennsylvania versus Casey, dealing with abortion. And everyone was kind of wondering which way the court would go in that case. It was an election year, 1992. It was kind of a huge case with big implications. A lot of attention was being paid to it. And in that case, the court ruled women still have a fundamental right to an abortion. We uphold the fundamental holding of Roe, that women have fundamental right to an abortion. And Souter was one of the people that ruled with the majority on that. As did Sandra Day O'Connor, another Republican. But it was really kind of Souter that caught a lot of people off guard because they thought he was one of them. And he said, no, I believe in stare decisis. So, here's my question for you. When it comes to abortion, is there a difference between believing in stare decisis and believing that abortion is settled law?
Yeah.
What do you think that difference is?
I don't know, I just said yeah.
Yeah. Which do you think carries more weight? Stare decisis, or if something is settled law?
Stare decisis.
Maybe? I don't know. Okay.
Either.
Well, anyway, that's kind of become an important debate. Brett Kavanaugh, when he was being appointed to the court during his confirmation hearings, he was asked questions similar to that, mm-hmm. and he was kind of evasive on whether, because some Supreme Court justices have said Roe versus Wade is settled law. And settled law kind of carries the connotation, it's done. It's decided. It's settled. We're done with this, right? We're going to abide by precedent. Whereas, the court is allowed to overturn precedent. Mm-hmm. It's allowed to. It does it all the time. As you mentioned, Plessy versus Ferguson, the court overturned that precedent in Brown versus Board of Education. So, that's an interesting question, Is settled law more stable than just believing in stare decisis? Mm-hmm. But anyway, okay, so you got stare decisis?
Yeah.
Okay, so another, we talked about judicial self-restraint, We talked about judicial activism, kind of another approach when judges hear a case is how much they believe in stare decisis. So it's kind of a different dimension than those other two. All right. Okay. Now let's talk about the next thing, which is a writ of certiorari. And this is a formal writ used to bring a case before the Supreme Court. If you're wondering how that's spelled, it's in your textbooks. I'm not spelling today. Certiorari. Certiorari. Writ of certiorari. And this, again, is from the Latin, and it means to be informed. It's the passive infinitive, for all you Latin buffs out there. So,
oh, wow, yeah.
Yeah, so, the court over its history has heard a different mix of cases, right?
Yeah.
Right now, basically,
yeah,
the court has total discretion over which cases it hears and which cases it doesn't hear.
Really?
Yeah. Right. See, like I said, over its history, Congress has said, if a federal district court disagrees with this, the court has to hear it, blah, blah, blah. But now, basically, the court has total discretion over which cases it hears and which it doesn't, right? And so, all the cases reach the court on appeal or by appeal. Mm-hmm. And so, in other words, the court gets about 8,000 to 9,000 of these writs each term. 8,000 to 9,000. Now, does the court have time to hear 8,000 to 9,000 cases?
Not before they're dead.
Yeah, exactly, right? And so, again, this varies a little from court to court, but just to make the math easy, the court takes about 80 to 90 cases a term, right? So, in other words, they take about 1% of the cases. No, that's right. Okay, so let's discuss some of the implications of this. Number one, some people say, I'm going to take my case all the way to the Supreme Court, right?
Yeah.
Is that person really deluded?
Yes.
Yes.
There are other cases.
there are other cases.
They don't care about you as much as you think.
That's right. What are the chances of the Supreme Court taking your case?
1%.
1%, about 1%. Exactly, right? So, to illustrate this, I felt kind of sad for a guy. There was a guy, Maurice Claret, was that his name? Anyway, he was a running back for Ohio State, and they won their national championship his freshman year, right? And he wasn't much of a student. He didn't want to go back to school. He wanted to go straight to the NFL.
Yeah.
But the NFL had a rule that you had to be 3 years out of high school before you could play in the NFL. And the reason that they have that rule is because in the NFL, most guys need a little more time to do strength conditioning, gain weight, be strong enough, or they're going to get killed out there, right?
Well, yeah.
Yeah.
It's the NFL.
It's the NFL, exactly. Here comes the boom, right? And so...
Don't take it easy on me.
No, not just because you're young, right? Yeah. And so the NFL had a rule saying you had to be 3 years out of high school before you can play in the NFL, right? Mm-hmm. And so he filed a lawsuit saying, I'm going to challenge this. And it went through the lower courts, and basically it never reached the Supreme Court because the lower federal court said this question's already been decided, basically. The NFL is a monopoly. It's been decided, and that's just the way it is, and you're out of luck. So, I know. And so he couldn't go back to school because he'd ended his eligibility. He'd signed an agent who filed the lawsuit for him, and his agent kind of deceived him by saying, "Well, we're gonna fight this. We're gonna take it all the way to Supreme Court." And this young kid didn't know.
Because he wasn't sitting in his.
Because he wasn't
sitting in his political science 101 course.
200.
200. My apologies.
He wasn't sitting in political science 200, and he didn't know the Supreme Court's not taking your case. It's you got a 1% chance. Yeah, it is kind of sad. So that was the end of his football career, basically, and. Yeah, no, I'm 99% sure his name was Maurice Clarett, but he was running back for Ohio State the year they won it in the early 2000s. So, okay, now let's move on to an amicus curiae brief. Lots of Latin today. This is literally a friend of the court brief. Amicus, amicus. Amicus, friend, from which we get such words as amicable, friendly, curiae, court, and there's the genitive of the court, curiae, friend of the court. So literally a friend of the court brief filed by an organization or individual to present arguments in addition to those presented by the immediate parties to a case. So, in other words, sometimes the immediate parties in a case have arguments to make and that they care about and that the court is going to consider. Mm-hmm. But amicus curiae briefs introduce other arguments that maybe the court hadn't thought about, right? So to illustrate this, one of the most famous amicus curiae briefs ever was called the Green Brief, right? Mm-hmm. And it occurred in an affirmative action case, right? And years ago, we'll talk about this later when we talk about affirmative action, the court was looking at race-based preferences in college admissions, right? So we'll talk about this more later when we get to affirmative action. But a public university, Michigan, wanted to continue to use race as an admissions criterion when making admissions decisions in order to accomplish the compelling government objective of racial diversity in higher education, right? Mm-hmm. And so they were making arguments about that. We need more racially diverse law school, undergraduate school, this type of thing. They're making those arguments. Well, the U.S. military also filed an amicus curiae brief in that case, right? And they said the court may not have thought of this and is not going to come up in a case dealing with race-based preferences in college admissions, but we need to be able to take race into account when making decisions in the military for national security reasons in order to have high morale within the Corps so that you don't have leadership all white and the underlings of a different race, So
angry people.
Yeah, you're gonna have problems. So they said we, the U.S. military, need to take race into account when making certain decisions. And apparently that was a very influential brief. And the court looked at it and said, yeah, there are situations, higher education, in the military for national security reasons, where you may need to take race into account. I don't know. We're gonna trust the military on this, and so apparently it was influential. Okay. Now this takes us to our next term: the opinion of the court. This is an explanation of a decision of the Supreme Court or any other appellate court. Right? So the court issues rulings. It rules for one party and against another party. Mm-hmm. But then they also include their reasoning. And the reasoning is extremely important, right? To give you an example, in a Second Amendment case dealing with your right to keep and bear arms.
Everyone likes that one.
Yeah, D.C. versus Heller. A case reached to the Supreme Court. D.C. had put a number of restrictions on handgun ownership, and other restrictions on firearms, because D.C. is an urban area, not a lot of hunting, right? Yeah. And high crime rates, so they had a lot of restrictions on guns. A gentleman who wanted to own a gun and keep it loaded for self-defense purposes filed a lawsuit saying, all these laws are really restrictive and are denying me my Second Amendment rights, right? That was Heller. So this case reached the Supreme Court, and the Supreme Court said a lot of these D.C. laws are unconstitutional. You have a fundamental right of self-defense. Mm-hmm. Right? Fundamental right of self-defense. Now, where do the words fundamental right of self-defense appear in the U.S. Constitution? Trick question.
They don't.
They don't. Exactly, right? And so this is kind of an interesting case because remember how we were talking about judicial restraint versus judicial activism earlier? Mm-hmm. See, a lot of people disagree over when the court is exercising judicial self-restraint and when they're being activists, right? Yeah. So they basically said you have a fundamental right of self-defense, even though those words do not appear anywhere in the U.S. Constitution, right? So consequently, you have the right to keep a firearm loaded and ready for self-defense purposes in your home, right? And that was in D.C. versus Heller. That's an interesting opinion, right? Because, well, number one, as I pointed out, where do the words fundamental right of self-defense appear in the U.S. Constitution?
They do not.
They do not, right? But who interprets the U.S. Constitution? The Supreme Court, exactly. So they're the ones that interpret the Constitution. So after this case that 5 justices agreed to, right? That's a majority. That establishes precedent. And now, does the U.S. Constitution guarantee a fundamental right of self-defense?
Yes.
Yes, it does, because that's what 5 justices agreed to, right? And whatever 5 justices agreed to become precedent. And they're the ones that interpret the Constitution. You know another one on this? Are you listening to me?
Yeah.
And another one on this dealt with the Establishment Clause, right? And if you take me for constitutional law, we'll talk about the case in more detail. But the Establishment Clause says Congress shall make no law respecting an establishment of religion, right? And there was a case that reached the Supreme Court back in the 40s that said what the government's doing is inappropriate here because it's aiding religion, right? Basically what happened was the government was reimbursing people for transportation costs incurred while sending their kids to private religious school. Yeah. And so people said, well, that's tax dollars that are going to help them receive private school instruction. And other people said, no, it's just tax dollars helping them receive transportation. They just happen to be going to a private school, right? Well, that case reached the Supreme Court. And the Supreme Court said what the government is doing here is just fine. They're just helping people with transportation costs. They're not helping people necessarily receive religious instruction directly. And so in that case, they said the First Amendment has erected a wall of separation between church and state. This wall must be kept high and impregnable. We could not approve the slightest breach. New Jersey has not breached it here, right? So, again, trick question. Where does the phrase wall of separation between church and state appear in the U.S. Constitution? It does not. But as soon as 5 justices agree to those words, does the First Amendment erect a wall of separation between church and state? Yes, it does. It constitutionalizes the phrase, right? And until 5 justices overturn it, then the First Amendment erects a wall of separation between church and state, right? Yeah, exactly. Okay, now another really good example of this was Lawrence versus Texas, 2003, where the opinion of the court is really, really important. So, at the time, Texas had a law that made it illegal to engage in adult, consensual, homosexual sodomy. Right? Adult, consensual, homosexual sodomy. Made it illegal. Right? Well, these 2 guys were engaged in adult, consensual, homosexual sodomy, right? And an officer was legally present when the officer saw this occurring. The officer was actually responding to a possible weapons disturbance. He was legally in the house when this was occurring. He was let in by a housemate type of thing. He saw this going on. Arrests were made. Prosecutions occurred. Case went to the Supreme Court. And the Supreme Court said to the state of Texas, why have you outlawed adult, consensual, homosexual sodomy? Now, if you're an attorney for the state of Texas, what would you argue in that case?
Well, the only basis would be religion, but no, you
can't make that argument, right? You can't make the argument, it's against the majority's religious beliefs.
Yeah.
Because then that's a law based on religion, and there's no state interest. So give me a state interest, state of Texas.
I do not have one.
You do not have one, exactly. And so, these laws are on the books in a bunch of states. And it's not until the state is dragged in front of the Supreme Court and asked to defend the law that they're left going, we don't have one. Other than the majority doesn't like it.
Yeah. Or
the majority thinks it's wrong. Or the majority thinks it's inappropriate, right? And the court said, if you're going to interfere with a fundamental right, like your ability to express affection towards someone that you're attracted to, then the state needs to come up with a better interest than the majority just doesn't like it. Mm-hmm. Right?
It's not a good reason.
Well, exactly. And that's in the opinion of the case, right? That's where that appears. And so the court basically said, the majority not liking something is not a legitimate government objective. You have to if you're going to interfere with someone's fundamental freedoms, you have to have a better government objective than just the majority doesn't like it. Right? Okay, so now with that ruling, Lawrence versus Texas, 2003, right? And now let's go back to another case, Loving versus Virginia, which was heard in the 1960s.
I know about this one. We read about it in GRC.
Exactly. So Virginia had a state law banning interracial marriage, right? The Lovings went through all kinds of challenges because they were an interracial couple that wanted to get married, and they had to go to D.C. to get married. Then they went back and were, persecuted for it, and then had to leave, and all this back and forth, and it was a nightmare for them, right?
Yeah.
So they filed a lawsuit. Case went to the Supreme Court, and the Supreme Court asked the state of Virginia, why do you have this law banning interracial marriage, right? And if you're an attorney for the state of Virginia, what do you answer?
I do not know.
You're not a very good attorney. You're going to have to come up with something better than that. We're paying you good money.
Yeah.
What are you going to come up with? Try to come up with something.
I would say, as a state, it goes against our beliefs of what should be accepted from our courts as a marriage ruling, because we give out marriage licenses for the state of Virginia.
See, that's the best argument you can come up with, right?
Pretty crappy one, huh?
But the court says that doesn't cut it.
Yeah.
Again, you're interfering with somebody's fundamental right? Fundamental right to get married, to enter into a contract with someone that you love and care about, and that you want to enter into this, quite frankly, it's a legal arrangement with. The state's got to give me something better than the majority just thinks it's wrong. And in all actuality, it was based on people's religious beliefs.
Yeah.
And again, that's not a state interest. It's rooted in people's religious beliefs. So in Loving versus Virginia, the court struck down state laws that banned interracial marriage. And so, between Loving versus Virginia and the reasoning in Loving versus Virginia and Lawrence versus Texas,
yes,
right? This paved the way for the court's ruling in 2015, Obergefell versus Hodges, legalizing same-sex marriage, right? So you're a state of Alabama, you have a state law banning interracial marriage. You're an attorney for the state of Alabama, same-sex marriage. You're an attorney for the state of Alabama. Why does the state have a law banning same-sex marriage?
As a state of Alabama who gives out marital licenses, we do not believe that combines with our beliefs as the thing.
Yeah, you can try and make that argument. It's not in harmony with our beliefs about what a marriage should be. Case went to the Supreme Court. It wasn't at Alabama. It was from a different area. Yeah. But they relied heavily on Loving versus Virginia and Lawrence versus Texas. And they said there's no legitimate state interest here. You just can't show us any legitimate state interest for banning same-sex marriage. Mm-hmm. So the point of this is the opinions in Loving versus Virginia and Lawrence versus Texas basically paved the way for Obergefell versus Hodges. Mm-hmm. It's the opinions that did it. Okay? Now there's also a dissenting opinion an opinion disagreeing with the majority in a Supreme Court ruling. So sometimes a justice will disagree with what the majority's decided, and they'll issue a dissenting opinion. And it carries no legal weight.
Yeah.
You're just kind of hoping to expose flaws in the court's reasoning. You're appealing to future generations. Scalia was known for writing very colorful dissenting opinions. And when he was asked why he wrote dissenting opinions, he answered, for law students, because they're the only ones who read them. No, I know. He's actually a pretty funny guy. The average American never reads dissenting opinions, which is too bad because, I teach constitutional law, and a lot of the time, really valid arguments are made in the dissenting opinions, and you realize, this isn't as straightforward as it appears if you only read the majority opinion, right?
Yeah.
So
one side of a debate.
Yeah, exactly. So an excellent example of a dissenting opinion was Justice Hugo Black in Griswold versus Connecticut. Again, in class we've discussed this case a lot. Law in the late 1800s banned contraceptive use in Connecticut. The Supreme Court struck down that state law and said you have the right to privacy. The decision whether or not to use contraception is a personal one, and the state has no business interfering with that. Well, Justice Black wrote a dissent in that opinion, and he said, I like my privacy as much as the next one, but unless my right to privacy is clearly protected by the Constitution, I'm not just going to invent new rights that aren't in the Constitution, right?
Yeah.
So in his dissent, he said, I'm protected against unreasonable searches and seizures. I'm protected against the government quartering troops in my home during peacetime. I have First Amendment free speech rights. I have all kinds of rights, but I don't see a right to privacy here. Right? So he issued a dissent in that case. Another guy, there were two justices that dissented in Griswold versus Connecticut. Hugo Black from the great state of Alabama. And like I told you, his reasoning, I like my privacy as much as the next one.
Yeah.
but I have to admit, unless it's clearly protected in the Constitution, there is no right to privacy. The other person that dissented in the case, the other justice that dissented, was Potter Stewart. And he had one of the most famous lines ever in the dissent. And he said, I think this is an uncommonly silly law. Right? And he basically said, if I were a member of the state legislature in Connecticut, I'd vote to repeal it. But I find no right to privacy in the Constitution. Right? So I defer to the state on this one, and the state is allowed to outlaw contraceptive use if it wants to. But that phrase, I think this is an uncommonly silly law. That was it was in the dissent, and became famous. All right, next, concurring opinion. This is an opinion that agrees with the majority in a Supreme Court ruling, but differs on the reasoning. So, how much time do I have here? Let's just stick with Griswold versus Connecticut since we're running out of time. The court found that you had a right to privacy. 5 justices agreed to that, at least 5. So that establishes precedent. But then they had to say, where's your right to privacy found? Right? And some of the justices said, well, it's a combination of the First, Third, Fourth, Fifth, and Ninth Amendments. Right? So, First Amendment. Do you have the right to associate with other individuals who share your views and petition government for a redress of grievances?
Yes, I do.
Yes, you do. Does this also mean you have the right to exclude people who do not share your message?
I guess so.
Absolutely, because that would interfere with your message, right?
Ah.
So, in other words, leave us alone. Well, seriously, leave us alone. We're doing our thing here, right? Okay, Third Amendment. Government can't quarter troops near your home during peacetime.
Mm-hmm.
So, in other words, if the government wants to put troops into your home,
we better be in a war.
well, we better be in war. Otherwise, what do you say to the government?
I said, violates my Third Amendment rights.
That's right. You know, get out of my house. No, you can't come in, right? Fourth Amendment, you're protected against unreasonable searches and seizures. Government wants to look in your purse without a search warrant, right? What do you say?
It violates my Fourth Amendment rights. Get out of my stuff.
Get out of my stuff. Leave me alone. It's none of your business. What's in your purse? None of your business. Fifth Amendment, you can't be compelled in a criminal trial to be a witness against yourself, right? So if you're in a criminal trial, the state asks you, where were you on such and such a night? What do you answer?
Violates my Fifth Amendment rights. I don't have to say anything.
I don't have to say anything. None of your business, right?
Yeah.
And then the Ninth Amendment, which is a gold mine, right? Yeah. It says, technically it says, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage other rights retained by the people. Mm-hmm. Right? So in other words, we listed certain rights, but you have other rights that we didn't list, and those other rights are just as important as the ones we listed. So, in other words, you have other rights in addition to those listed in the first 8 amendments of the Constitution, and they're just as important as the ones we've listed. Yeah. So, where in the first 8 amendments does it say you have the right to get married?
It doesn't.
It doesn't. But do you have the right to get married?
Yeah.
Absolutely. It's just fundamental human right. Where in the first 8 amendments does it say you have the right to have children?
It doesn't.
Doesn't. Right? But do you have the right to have children?
Indeed.
Mm-hmm. Absolutely. Do you have the right to tell them there's an Easter bunny?
Yeah.
Yeah.
Unless
since this is on YouTube.
Backstab you. As soon as you get old enough.
Well, exactly.
I'm not bitter.
Parental rights are pretty broad. But anyway, yeah. You can tell them about the Easter Bunny, Santa Claus, Leprechaun. You leave little leprechaun soccer balls out. Anyway, you can, you have all kinds of rights, right? Mm-hmm. So anyway, back to Griswold versus Connecticut, the Supreme Court said, oh yeah, you have a right to privacy. 5 judges agreed to that, right? But the thing is, there were a number of concurring opinions, and they said they're all over the place. Like I said, some said you find your right to privacy in a combination of the First, Third, Fourth, Fifth, and Ninth Amendments. Other justices said the Ninth Amendment alone is enough. Other justices said the 14th Amendment. You can't be deprived of life, liberty, or property without due process of law. The 14th Amendment alone is enough. So there it is. Concurring opinions. So, concurring opinions give a justice an opportunity to agree with the ruling. This law is unconstitutional. Mm-hmm. You have a right to privacy. But then in the concurring opinion, they can give their particular reasons why. Make sense?
Yep.
Okay. Now, just 30 more seconds. How does it make you look when you find a new right that's not listed in the Constitution and you can't agree on where it is found?
You sure you found it?
Well, does it strengthen or weaken your argument?
Weaken.
It weakens it, exactly. Here, that was a wonderful lecture. See you guys for our next lecture. Come help me turn this off.
Yeah.
Is it just this button here?
Yes.